Good day, Crime Talk aficionados. My name is Scott Reisch, and this is the Crime Talk Weekly Recap, highlighting the major stories from each day of the week. I hope you watch it, and I hope you enjoy. Thanks for watching. There have been a lot of new motions and filings in the Lori Vallow Chad Daybell matter. A lot of these motions that are being filed are in response to motions filed by Mark Means seeking to compel the government to turn over discovery that he believes has not been turned over. That has resulted in a hearing that has been set on the February 17th at 9:30 a.m., and we'll bring you that hearing live. Now, this is a hearing regarding the motion to compel. We've been able to glean a little bit of information since the court has not made the motion that was specifically filed by Mark Means available. However, based upon the responses in the government's motions, we can tell quite clearly what Mark Means has been asking for. And the response to the supplemental declaration of counsel Mark Means in support of his motion to compel, the government has went back and looked at their files, and they basically have said that, hey, everything that we're required to turn over, we've already turned over to Mr. Means. And in our discovery and review of all of the discovery, out of an abundance of caution, we couldn't verify that Mr. Pryor, Chad Daybell's counsel, had received several statements and reports, and therefore we are sending those to him once again just to make absolutely certain that he has the discovery. And in the response, the government states that in the same phone/device forensic report listed above that they refer to, they state that they were provided to Mr. Means' counsel for Lori Vallow on or about the week of May 18th, 2020. And the prosecution goes on to state that both defense counsel have received the same discovery to date. Now, we talked about this a little bit. And in the criminal realm of the practice of law, the courts don't like you rushing to the court if you think there's a discovery dispute. That's a little different in the civil world. In the civil world, you really don't go to court that often. And so if there's a civil dispute, you basically call up the judge and say, "Judge, they're not giving me something," and they resolve it. I can tell you as a practical matter, and we do this all the time in my practice, if we're going through the discovery, we make a list of things that we think that have not been turned over. And we send a nice letter to the district attorney saying, hey, we haven't received these documents, reports, interviews, whatever it may be, that were referenced in the discovery. Could you please provide them? 99% of the time, the district attorney is going to say, hey, you know what? Thank you. I thought this had been turned over, or I haven't seen it myself. Let me follow up with the detectives because it's my duty and obligation as a prosecutor to turn everything over to you. That is my experience. On a rare occasion, if the prosecutor is not turning something over, you have to file a motion to compel or motion to produce the discovery, and you go to the court. The first thing the court's going to ask is, well, have you asked the district attorney? And you usually attach to your motion the nice letter that you sent to the district attorney saying, hey, I haven't received this. And then the court says, okay, I hope the district attorney has a really good response here because clearly defense counsel has not tried to bring the court into discovery issues since discovery is an ongoing and continuous process for the prosecutor. And courts don't have time to deal with petty disputes, so you better make sure you got it right. Now here, the prosecution is saying that Mark Means has received this discovery back in May of 2020. Ooh, that's the kind of thing, before you go filing motions saying you haven't received something, you go back and double check. You go back and ask your assistant to go find this discovery and somehow double, triple check before you go to the court that you haven't received it and maybe you just missed it. Maybe it got put in a different file. Who knows? But you don't go to the court. The other response that was filed by the prosecutors in regards to the request by Mr. Means to have his client, Lori Vallow, have access to a cell phone. Not surprisingly, the district attorney said, "Are you kidding me?" Because guess what? A cell phone would be contraband in the jail, and therefore there's no exception for Lori Vallow to have a cell phone. Additionally, this is the job of the sheriff, and we're not going to get involved in that particular issue. Other reason why Mark Means wants to have a cell phone for his client is that he states that his client and their communications together were somehow being monitored in some particular way, and that's interfering with his client's right to counsel under the Sixth Amendment, and therefore, once again, she's special. I've said this before. I've never heard of such a request. I couldn't imagine that a judge or a district attorney would agree to such a request. The district attorney, Mr. Wood, responds saying, "Are you kidding me? We already litigated this issue at the motion for bond reduction when there was an issue regarding attorney-client calls that were recorded. At that time, both the sheriff and the district attorney said one call was recorded by mistake. It was deleted. It had never happened again." Mr. Means also notes that everyone at the jail, attorneys, and Mr. Wood also notes in his motion that everyone at the county jail, as well as attorneys, all have to use the same communication devices. And if it is an attorney-client communication call, that those are not monitored or recorded. If they continue to proceed and it is not a flagged attorney-client call, yes, it could be recorded, but both parties are advised by a recording on the audio saying this call is being recorded. That's very, very common in just about every jail situation I've ever received a call from. A specific system at this particular jail, the Madison County Jail, is the telemate system, which they all have to use. So once again, I believe that Mr. Mark Means' motion will be denied. Now, in the response by the people, Mr. Wood, he attaches the previous pleadings as exhibits, specifically referencing these attorney-client communication calls. Basically, what this really is some sort of motion to reconsider. We all know how the court feels about motions to reconsider, is they're not really permitted unless you have some new or additional information. There's been no allegation made of any new or additional information in these pleadings from what we can tell. And in fact, that's why Mr. Wood attaches to his motion all of the exhibits from the previous hearings and explaining that there is no special rule for Lori Vallow to have a cell phone. The court is also going to be able to see Mr. Means' tweets where he states that the attorney-client communications were recorded and he is somehow taken to Twitter thinking that that is going to be some way to influence the court or get a better result here. Somehow, I do not think it will be at all. Now, what is of greater significance is Pryor, the attorney for Chad Daybell, has filed a declaration of counsel in response to the motions filed by Mr. Means. And I think this is rather interesting. He states that he is the attorney for Chad Daybell in the above referenced matter and makes the following declaration upon his own personal knowledge and belief. And he states, Mr. Mark Means does, says that my client is currently being held at the Fremont County Jail, that there has not been a single issue with the Fremont County Jail or their staff as it relates to visitation or treatment of his client at the Fremont County Jail. That given the tremendous amount of local exposure given this case, the Fremont County Jail deputies and the entire staff have responded immediately to any questions I might have and have conducted themselves as exemplary professionals. Their exemplary conduct and professionalism have been consistent throughout the entire process so far. That as it relates to Mr. Daybell, I have not had a single incident of any type and have not had the same experience that Mr. Means has apparently had at the Madison County Jail. Bottom line is, different jails, okay, fine. One's in Madison, one's in Fremont. Is this his way to get the clients in the same situation? Don't know. I personally think that it is a way of Mr. Pryor trying to say, hey, I haven't had any problems. I don't want to be associated with any of this or somehow think that I'm joining in this motion in any way whatsoever. And in the final motion, the discovery of disclosure, the prosecution has stated that pursuant to the criminal rules of procedure, Rule 16, which is self-executing and ongoing, that all of the statements of the defendant, the co-defendant, defendant's prior records, documents, and tangible objects have either been made available, produced already, or the defense counsel and their investigator can come at a mutually convenient time and photograph and inspect all of the materials. The district attorney states, in fact, all the reports of examination and tests attached as Exhibit A. Witness statements from state witnesses will attach those as Exhibit B. Expert witnesses, addendum. Police reports previously been provided, detailing everything that is out there and everything that has been turned over. So, what will ultimately take place on the 17th at 9:30 a.m. before the Honorable Judge Stephen W. Boyce? I do believe that the defense, specifically Mr. Means and Lori Vallow, will not, and I say again, will not have any of their motions granted, as it appears the prosecution has done everything they can do, and it's very unlikely the court would grant, even if it wanted to, a cell phone for Lori Vallow. So I believe this is another embarrassing situation for Mr. Means and Lori Vallow coming up on Wednesday. First on the docket today, Mark Means. Some people are starting to think that it's something personal that I have against Mr. Means. Nothing can be further from the truth. I just don't understand what he's doing. That's all I'm saying when I talk about Mr. Means. So far, just about everything that he has requested has turned out to be frivolous. As most of you know, as we talked about this yesterday in our video, that there's a hearing scheduled for February 17th at 9:30 a.m. Mountain Time. That hearing has been set. If you take a look at the setting for the motion to compel, which was set due to the motions filed by Mr. Means and Mr. Pryor, basically saying, hey, I don't really have all of this discovery. And let's be candid, it was Mr. Means who was saying he didn't have the information. He also wanted his client to have a cell phone at the jail so that he can speak with her. Well, the court set this motion to compel for February 17th back on January 20th. So literally almost a month. So what does Mr. Means do today? Yep, you guessed it. He filed a motion to continue today, saying that, for lack of a better term, he didn't know about it. He is also requesting, in a motion caption that makes little to no sense to me, motion for status conference under seal. So I guess he wants a status conference with the doors closed and no one being able to see, which is probably a violation of his own client's constitutional right to a public hearing, a public courtroom as it relates to our matter, and a request for hearing schedule on defendant Lori Vallow's motion for reconsideration. We've talked about this. The court already denied the motion to reconsider, saying that there is no basis in the criminal rules in Idaho to hear the motion to reconsider. We've discussed the fact that you must have some new information and you refile it. You don't just get to keep asking over and over again to do that. Judges normally don't change their mind. They believe they made the correct decision the first time, unless there's some new information presented. But the kicker is in paragraph 2 of this motion, and I'm going to read it verbatim. Paragraph 2, requests a hearing schedule date on defendant Lori Vallow Daybell motion for reconsideration. Unbeknownst to counts, COUNSE, comma, L, this matter was set without notice of setting date for February 17th, 21 at 9:30 a.m. before this court. Counsel would like to file his memorandum in support of this motion in compliance with the Idaho Rules of Criminal Procedure notice requirements detailing arguments for said motion. Thus, defendant requests this is vacated for tomorrow hearings and set on an available time for counsel and this court. Perhaps Mr. Means is in a rush because he filed this and most of that second paragraph makes no sense. There are typographical errors as well as grammatical errors. Understand these things happen. Understand sometimes you think, hey, I didn't get notice of this. However, since the cases were joined, Mr. Means would have received notice from the court as it was filed in the Chad Daybell matter. Additionally, this is public record, and as a practical matter, if you have dates or you're not uncertain, sometimes you're not sure if you wrote something down, you think, hey, was there another date set? You or your staff call and confirm the date. Now, if I, as a member of the public, can confirm that there is a hearing date set out almost a month ago, that Mr. Means probably should have been aware of this hearing. It'll be interesting to see if the court allows the motion to continue, because motions have already been continued. They've been set out to March on the motion to dismiss, and it just keeps continuing. I somehow think, I'm taking a guess, and I'm telling you I'm taking a guess, I think the court denies this, makes everybody show up tomorrow morning at 9:30, and Mr. Means will more than likely have to get coverage for other matters, as this, I'm sure, would take precedence. It's nothing personal. I'm just saying, really? You got to be kidding me. The biggest case of your career, and you don't know when the next court date is scheduled? Not good. Not good. The motions hearing went forward today in the Lori Vallow Chad Daybell matter. As you may recall, last night we discussed it that Mr. Mark Means, the attorney for Lori Vallow, had filed a last-minute motion to continue, saying that he didn't have this on his calendar and really wouldn't be able to proceed forward today because he wasn't going to be prepared. I thought maybe the judge would grant it, but I was pretty certain that the court would go forward. Sure enough, the court went forward. We carried it live, and I provided my analysis of what took place at that time. But let me give you the thumbnail version of it right now. First, Mr. Means had filed a motion for discovery, basically a motion to compel the prosecution to turn over any statements that existed. And it was a very broad and large list of things that the defense wanted. Mr. Wood, the attorney for the prosecution, did get admonished by the judge a little bit as to why he did not respond within the 14 days permitted under the rule. And Mr. Woods basically said, well, at the same time, Judge, I was kind of dealing with this other issue of being disqualified, so that was kind of my focus. But once that was all resolved, I did in fact respond. And the court has a provision under Rule 16 where if they can show good cause or excusable neglect, that the request or the objections to the request are not waived. That's what the judge found. No bad faith, no waiver on the part of the prosecution, but the prosecution was ordered to basically go back and check and see if there's any other statements out there that may exist for any witnesses in this case that have not already been produced. Mr. Wood said he would comply. The overly broad documents and requests that were made by Mr. Means were denied. So Mr. Means' motion was granted in part, denied in part. He got what he's already entitled to, and he didn't get what he's not entitled to under the law. The second issue on that motions hearing today was the fact that Mr. Means says that his client's right to communicate with his attorney is being violated because he cannot meet in an attorney-client conference room at the jail, and that he has to deal with situations related to COVID, the fact that his client's in custody, the fact that it is being recorded. So Mr. Means says, I want to be able to meet with my client. I don't want any video going on. and ultimately just give my client a cell phone so that she can call me at her convenience. Understood the pressures and the reality of a COVID world, as well as the need to meet with your client face-to-face. However, the court stated, I have no jurisdiction and I'm not going to get involved in these matters. Basically, I'm not going to tell the sheriff how to run his jail. They have to do what they need to do to maintain good order, discipline, and security, and he's not going to get involved with that. Mr. Wood said he's never heard of this request before being made in regards to the cell phone. Frankly, neither had I. Hey, I guess you get A+ for creativity, but I couldn't imagine that an item that is considered to be contraband in a jail was going to be granted, i.e. a telephone. The judge suggested that perhaps Mr. Means call the jail before he heads down there so that they can make sure that the attorney-client visitation room is available. On the issue of calls being recorded, Mr. Means basically said this has happened maybe 3 or 4 times. Mr. Wood said it happened early on because Mr. Means didn't provide his telephone number so they could block those calls from being recorded. Mr. Wood said I provided that information to them early on and that this was really the first that he's heard of it. But since he didn't call me, I didn't really take any action on it at this particular time. You can also tell that the relationship, the professional relationship between Mr. Means and Mr. Wood is very acrimonious. At one point, the judge had to admonish Mr. Means and then said that counts for everybody else. Don't interrupt any other party while they're speaking. And Mr. Means was pretty quiet thereafter for sure. That's what takes place in court. One party speaks at a time. Nobody's talking over anybody. Needless to say, all those requests were denied, other than the court said, yes, you should be able to meet with your client in a space if it's available, coordinate with the jail so that that can take place. But I'm not getting involved in anything else. And that was it. Kind of like what I said I anticipated would happen took place. The hearing would go forward. A lot of documents weren't going to have to be turned over that were requested. And ultimately, Lori Vallow was not going to get a cell phone. All right. There you go. I encourage you to watch our live today. It's interesting. You can see, I think, the tension between the attorneys in the case. They really do not like each other. And I think the fact that we're in front of the judge to resolve these discovery issues is because the professionalism completely went off the rails in this particular case, and neither side is going to do anything as far as communicating with the prosecution and defense unless they absolutely have to. Sounds like everything's going to be done on the record in open court, so no one can be accused of doing or saying anything unethical or illegal, since Mr. Means has accused the prosecutor of that, and he did again today in his motions at least, that Mr. Wood is basically an evil guy withholding all kinds of statements and making his life miserable. So court didn't agree once again. Next on the docket, do you recall last week we brought you a story about Derek Chauvin? He's the police officer charged obviously in the George Floyd matter, and he's the one primarily charged. The other officers, former officers, Officers Tao, Koenig, and Lane, had their trials severed. Well, there was a newspaper article that went out, and it discussed the fact that early on, Derek Chauvin was prepared to plead guilty and receive a federal sentence of about 10 years. Now, then Attorney General William Barr put a kibosh to that. So the attorneys for the now former police officers have filed a motion asking that the charges be dismissed, specifically saying that there's no room to allow the prosecutors any wiggle room to refile the case in the future. And they asked for a litany of sanctions, including a judicial order to ban whomever leaked the materials from participating in Tao's trial, and a ban on allowing outside lawyers to participate in the case. Naturally, they've also asked for the order banning jurors from serving on a case if they've heard of the leaks. Clearly, this goes directly to the 6th and 14th Amendment of the United States Constitution, and those provisions guarantee criminal defendants the right to an impartial jury. When you read the motions, they basically accuse Minnesota Attorney General Keith Ellison and prosecutor Matthew Frank and Special Assistant Attorney General Neil Catel of various forms of and levels of misconduct under Minnesota case law and the state's rules of professional conduct. In Tao's motion, it states, "It is impossible to overstate the magnitude of this misconduct or its prejudicial effect on the defendant's constitutional due process rights of a fair trial. If this leak would have happened during the trial, the court could be required to declare a mistrial and to dismiss the charges with prejudice." Koenig's motion more broadly accuses government actors of a wall of prosecutorial misconduct involving both leaks and other matters. It describes nefarious motives of Mr. Ellison for failing to personally participate in a court hearing after stating in an email that he would be personally present at a meeting immediately following the hearing. Mr. Ellison's late decision to absent himself from the hearing suggests he knew about and may have personally been involved in developing the strategy to cheat the defendants out of their right to due process. Mr. Ellison distanced himself and did nothing to intervene or to correct the state's ill-intentioned conduct. So here's what this means. Plea negotiations take place in cases all the time. That's what everybody does. Prosecutors say, hey, I don't know if your client did it. I don't know if he wants a trial or not, but here is an offer. You say, that's ridiculous. My guy didn't do it, but he'll take this. Okay. But jurors are never supposed to know of any sort of plea negotiation that's taking place. And the prosecution leaking this information goes directly to a defendant's right to a fair trial by saying, oh, they were going to plead guilty. They would have pled guilty, but, we didn't think it was going to be accepted. That is inappropriate. Whomever leaked those documents to the press, and if they are an attorney, should face sanctions, no doubt. And if it was the Attorney General himself, Mr. Ellison, he is going to have or should have even bigger problems. But what does this really represent? I think this represents that the state is starting to realize their case is not getting better as time goes on. As time goes on, people are obviously still upset about the case of George Floyd, but the evidence that was more than likely is going to be presented from the defense is that George Floyd died of a drug overdose. Yes, things could have been handled differently, but he died because of the drugs that he was on. That's going to be the defense. The defense is going to have experts to testify to that proposition, that theory of the case. I personally believe, and this is my opinion now, that the prosecution is getting concerned. They've had all of these trials severed. Derek Chauvin will go shortly, and then later in the summer, the remaining 3 officers will have their trial. That is not what the prosecution wanted. They want delay, and this is a way for the prosecution to potentially get that delay. I hope this judge, if he can determine who leaked those documents to the press, that this judge crushes them. And if they are an attorney, that attorney be sanctioned. That's just unfair, and it crosses the line. Please go to CrimeTalkSearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to CrimeTalkSearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to CrimeTalkSearch.com, sign up today. You'll be happy you did. Is Crystal Lee Kenny. Do you remember that name? Does it ring a bell? That's right. That was Nurse Crystal Lee Kenny. She was the married woman who was having a relationship with Patrick Frazee, who was kind of her boyfriend, who thought that she was going to do terrible things to the mother of Patrick Frazee's child, Miss Kelsey Barrett. And Crystal Lee Kenny, in exchange for her cooperation and testimony at the trial of Patrick Frazee, received a pretty generous plea agreement for her case. It was very good disposition for her, and I'm speaking from a criminal defense attorney's perspective. When you can plead guilty to one count of tampering with evidence, which is a Class 6 felony, the lowest felony that we have here in the state of Colorado, and it carries a presumptive range in prison of between 12 and 18 months. Not very long considering you're charged with murder. Now, a sentence can be aggravated where it can increase to twice the presumptive range. So 12 months to 18 months, twice the max presumptive range is 36 months, 3 years. Still a pretty good deal. Well, in Crystal Lee Kenny's plea agreement, she was agreeing that the judge could sentence her in the aggravated range. Now, she wasn't necessarily aggravated because she had no criminal history up until this point. Now, for a court to sentence somebody in the aggravated range, there has to be what there is known as aggravating factors. If one has a extensive criminal history, then the court can find aggravation. Also, by statute, if somebody was on probation, parole, and bond at the time, and they were ultimately convicted of that offense at the time of this new offense. But a United States Supreme Court case going back to the year 2000, it's called Apprendi v. New Jersey, and Blakely, which is another case from the United States Supreme Court, also states that if there's anything other than prior criminal history, that the aggravation must be pled and proven to a jury beyond a reasonable doubt. Now, in a guilty plea, for that to take place, you have to admit or stipulate to aggravating factors. Now, in the case of Crystal Lee Kenny, the court advised her that it could be an open sentence all the way up to 3 years. However, the appellate court said that at sentencing, the judge stated that in aggravating Kenny's sentence, he considered her oral admission at the plea hearing, her confession to learning that Frazee had committed a homicide, and he said that that was a significant part of the sentencing decision. But according to the appellate courts, the judge went on to explain why he felt the factual basis was an understatement of Kenny's action. The judge described in detail Kenny's involvement in the homicide perpetrated by Frazee and described Kenny's actions as cold, calculated, cruel, devoid of compassion for human life. And then based upon these findings, the district court sentenced Ms. Kenny to the aggravated range of twice the maximum presumptive range. The appellate court agreed that the facts the district court used to aggravate Kenny's sentence are certainly disconcerting. However, the appellate court said the district court made findings establishing the majority of the aggravating facts on its own. And under a case called Lopez, which is applicable in Colorado, in order for these facts to be the Blakely compliant, Kenny must have stipulated to judicial fact-finding for sentencing purposes. Basically, you have to let the judge make the decision whether there's aggravating circumstances. Otherwise, a jury would have to do that. Well, a jury wasn't going to do that because that was a guilty plea in place. So who is really to blame for this case getting remanded, reversed, and basically sent back for sentencing so that Miss Crystal Lee Kenny, can only get 18 months, which will more than likely have her released to parole for a period of 1 year in almost no time? A lot of people are. First, the district attorney. This plea agreement was a gift, and I get it. They did not have the remains of Miss Kelsey Barrett in which to go forward on. So they needed to make a deal with the devil, Crystal Lee Kenny. They needed her to prove the case, but they got sloppy, and they could have put in the plea agreement the stipulated facts to make it an aggravated sentencing range. Who could also be to blame? Could it be possibly the defense attorneys? Well, they were agreeing that it was a Blakely sentence, but then, and I must note, the appellate attorney is not the attorneys that handled the case at the trial court level. It's a little surprising that that was not worked into the plea agreement. Was that the plan all along on the defense side? I don't know. The fact that the district attorney wasn't more precise in their language, also significant. There should have been something in there that she would have agreed to waive any appellate rights. However, you don't see those very much at the state level, but they're always there at the district court level. Now, nobody wants somebody to spend additional time in prison if they don't need to. That would just be unfair, and it's the wrong thing to do. But also, could there be a little blame on the part of the court? The court went through and said, this sentence will be in the aggravated range. You're waiving Blakely. But because the court didn't make specific findings of that, then he could not have done that according to the appellate courts. So Ms. Kenny's going to get resentenced and no more than 18 months. What will be interesting to see is if perhaps the district attorney moves to vacate the plea agreement, since what Ms. Kenny was supposed to do and had agreed to do was not being done in the plea agreement. And I find it hard to believe. Ms. Crystal Lee Kenny had very competent attorneys. Her attorneys were two of the best that I can say that I know here in the state of Colorado. So I find it very hard to believe that they did not advise Ms. Kenny as to the fact that the sentence was going to be in the aggravated range and it could be up to 3 years. We'll see if the district attorney tries to push back in any way. We'll see if maybe the judge will try to say that the plea wasn't valid and make her reaffirm it and make the appropriate findings before he will go forward. Maybe he'll try to reject the plea, or maybe the court will just simply say, fine, I messed up. I didn't advise you properly. My fault. You get the benefit of it of 18 months. And guess what? If you mess up on parole, everybody's going to be watching, and I hope you go to prison for that extra year. But more than likely, Crystal Lee Kenny is going home. Let me know what you think. Who's to blame? Prosecutor, defense counsel, or the judge? Have a wonderful weekend. We'll see you next week on Crime Talk.